This is another one of those terribly sad cases that seem to come up so often in negligence law. Mazinski was born in Russia, but lost both of his parents during the Second World War in his early teens. He was a refugee by 1943 and worked in occupied Germany until 1950 when he emigrated to Australia. Nobody knew what post-traumatic stress disorder was back then, and like so many others, Mr. Mazinski self-medicated with alcohol. Around about 5:30 a.m. on the 29th of April 1976, Mr. Bakka was driving home after a late evening of socialising. He turned into his driveway, travelling very slowly. He did not see that Mr. Mazinski was lying in the shadows, deeply intoxicated, with half a bottle of wine by his side. Mr. Bakka ran over Mr. Mazinski, leaving him a paraplegic. The court found that Mr. Bakka did not owe a duty of care to Mr. Mazinski, because there was just no way to reasonably foresee that an intoxicated stranger would have been lying in the shadows of his driveway at 5:30 in the morning. However, the judge went on anyway to consider what the duty of care would have been if such a duty had existed. You see, there was a complicating factor, which was that Mr. Bakka had defective vision in one eye. So the court considered whether his duty of care would have been any less as a result of his poor vision. The court found that his duty of care would not have been diminished. The duty of care was to take those precautions which an ordinary person would take. That means the precautions to be taken by an ordinary person with ordinary vision. Mr. Justice Walters said of Mr. Bakka, his duty towards the plaintiff was to exercise the standard of care that could be expected of a reasonable and prudent driver in all the circumstances. He was obliged to guard against dangers which were reasonably possible. His duty of care was no less because he had defective vision in one eye. Indeed, that visual infirmity imposed upon him a higher duty to ensure that he was vigilant in his lookout for things that would be visible to a person with ordinary eyesight. As a result, the objective test, which asks what an ordinary person would do, is not modified to take account of a defendant's disabilities.